an important point to know is that the timelines, especially in relation to domestic arbitrations, that is arbitrations under Part 1 of the Act and not international commercial arbitrations, they will have to flow in accordance with the timeline specified in the Arbitration Act. Now, under the Act, previously in the 2015 amendment, the proceedings had to be completed within a period of 1 year from the date of constitution of the arbitral tribunal. This has been amended in 2019. Now, the position is slightly different. The parties have to complete their pleadings in a period of 6 months from the date on which the tribunal is constituted. Now, after this 6-month period, there is a further 12 months for the arbitration proceedings to finish. So, what you have essentially is a period of 6 plus 12, giving you 18 months to complete the arbitration proceedings. What happens in a case where the arbitration proceedings are not completed in these 18 months? In such a case, the parties, by mutual consent, may approach a court and seek an extension of the arbitration proceedings. And if the court finds that yes, there is merit in extending these proceedings, then they can do so by a period not exceeding 6 months. So essentially, the entire proceedings at best have to be completed within 2 years' time or 24 months.